Good afternoon, everyone. So, welcome to our webinar. So, today, our topic will be on protection of workers in cases of company closure, merger, etc., and termination of employment. So, our speaker will discuss key points on the said issue, and later on, after the discussion, you as viewers, if you have questions, we encourage you to just type it in and we'll read it after the discussion. So if in any case that the presentation of the speaker is not yet done at the given time, we may extend our webinar. So our speaker for today is PMAP's General Counsel. He is a trained human resources professional with experience in management, HR, and
of closure of corporations and other grounds. I was also tasked to discuss topics pertaining to employee dismissal, which is actually one of the most favorite topics of HR and labor relations practitioners. I have made a materials to share with you guys so that you'll be guided accordingly. Okay, let's discuss a discussion. Let's start the discussion by focusing on this issue of employee protection. I wanted to orient you guys that there is this constitutional provisions um, providing for too much protection to the workers as far as humane conditions of work is concerned. Okay, security of tenure, and would you believe there's even a mention of the term living wage in the Constitution? Okay, um, these provisions of the constitutions are basically the policy guidance that our legislative body and the government should be adopting. And this is the same premise which would focus the legislative work of our government. Now, I have highlighted to you that this so-called security of tenure protection, no less than granted by the Constitution, basically, however, is without restriction. No? There are some provisions of law that allows separation as far as dismissal of employees are concerned. Particularly, there is this discussion in the case of Agripino versus de Guzman, where the Supreme Court said that tenurial security is not really absolute. Um, what is prohibited is basically the whimsical dismissal coming from the company. So this is what is actually prohibited, the whimsical dismissal from employment. Um, the Supreme Court said that in cases involving dismissal, the court will have a clear view, a review of basically the grounds and the procedures by which dismissal is made, such that the court would normally take into the factual circumstances when dismissal was affected by the employer. So coming it up from this simple summary of security of tenure, I've just discussed to you the provision that there is as well to comply with certain regulations as far as restrictions on dismissal, employee dismissal is concerned. Because again, as I have already mentioned, this is not an absolute right of the employee insofar as continuous employment is concerned. What is actually prohibited is the capricious, again, I'd like to repeat it, the capricious dismissal coming from the employer. Capricious in the sense that it is not in accordance with the procedure, it's not in accordance with the grounds as established by the law. Now, I am showing to you in my materials, which actually you can share with any of your friends and or HR practitioners. There are two things which the procedure and regulations are required us to comply in any event of dismissal. Well, this is despite the security tenure provided for by the Constitution and that which is also enshrined in the Labor Code of the Philippines. Now, these two requirements are really indispensable that they have to coexist. Okay, the absence of one will make the dismissal as void. Therefore, the provisions of the Labor Code allowing reinstatement, payment of separation, payment and or reinstatement of employee will be triggered. So, what are these two elements required by law insofar as a valid dismissal is concerned? One, the law would require us that dismissal has to be conducted using the so-called substantive grounds, meaning the law would allow dismissal in the event that this grounds enshrined in the labor code is invoked by the employer. And I'm referring to these two collective grounds, one of which is referred to as the just cause, and the other one is referred to as the collective causes, authorized causes. We will be discussing each collective grounds as we go along the way. Now, the other requirement to make a dismissal valid is what we call the procedural requirement or the procedural due process. Lawyers would normally call it as the so-called twin notice rule, simply because the procedure essentially would require service of written notice to the employee, all of which is in the course of the concept of procedural due process. So again, going back, there are two essential requirements to make sure that dismissal becomes valid and therefore will not be will not be declared as void, thus triggering a possible impact of a reinstatement. So this requirement, again, going back first, as I mentioned, this must coexist. One, there should be ground, okay, and two, there should be due process, procedural due process. Now, when Republic Act 715 was passed, it amended the provisions of Article 297 of the Labor Code such that the impact in any event that a void dismissal would happen, the impact is that one, the dismissal would become illegal. Two, there will surely be an order coming from the NLRC to reinstate the employee. Three, the employee will be entitled to back wages from the time that he was illegally dismissed and or the benefit withholded by the employer up to the time that the employee would actually be reinstated and or the benefit being given by the employer. Now, this is a long period of time as far as liability is concerned. That's why I would really strongly suggest that the employer would really comply with these two requirements. Again, valid ground, two, valid observance of the procedures. Okay. Um, on the board, on the board, on the materials, you will see that these two requirements are, again, going back, substantial due process, meaning the grounds, okay? And two, meaning procedural due process, meaning the observance of procedure by which you can dismiss an employee, okay? Let us now discuss the procedural due process before we jump into the grounds that would allow you to dismiss an employee. Let's discuss first the procedure. As far as procedural due process is concerned, there is this concept of just cause and authorized causes. The procedures for both grounds are entirely different in the sense that if the dismissal will be based on just causes, there is a requirement of, as I had mentioned already, a twin notice rule. The first written notice required by procedure would be what we call an NTE or a notice to explain. Jurisprudence will tell us that an NTE has to be served to the violating employee, allowing the employee 5 days, again, 5 days, and I mean 5 days simply because this is a jurisdictional requirement of the court saying that this notice to explain issued less than 5 days, allowing the employee less than 5 days is illegal. Therefore, again, I'd like to give a stress. The period of time to explain will be 5 days, and that is 5 calendar days. Otherwise, the notice to explain will be void. Okay. Now, in the notice to explain, the employer is required to indicate the factual circumstances that will constitute the violation. This is on top of the 5 days requirement. Now, if there would be any evidence that the employer wanted to incorporate in the notice to explain, the better. Now, there are issues as far as employees not wanting to receive a notice to explain, and or employee simply ignoring the notice to explain tendered by the employer. Jurisprudence will tell us that even when the employee would refuse acceptance, the employer has to send it through public courier system with proof of transmittal and or postal service. There's also a process known as constructive receipt, which is an entirely different process with that of the mailing system. The concept of constructive receipt is such that the employee will give a copy of the written copy of the NTE to the employee. If the employee will refuse receipt of that NTE, all that the employer would have to do is to make notation on the receiving copy, notation as to when it was tendered, notation as to how it was tendered, accompanied by anyone and any attesting witness that can sign the notation that was made in the receiving copy, and presto, you have what we call constructive receipt. Okay, that is as far as the NTE is concerned. Now, to complete the so-called twin notice rule, lawyer would again call it as twin notice rule because there are two required written notices for just causes. These are grounds by which an employee made a violation. We call that as just causes. The second notice is what we call a notice of disciplinary action, or the NDA. The notice of disciplinary action is also a written notice where the employer is actually coming up with a summary of the factual finding that it has made insofar as the investigation is concerned, and imposing upon the employee a sanction, whether it be from a minimal of verbal warning to a probable maximum imposition of dismissal. Now, the NDA, again, it is called NDA or Notice of Disciplinary Action, will be served just like the NTE or the Notice to Explain. Again, there is this possibility that the employee would refuse, so the employer can always go to this so-called public postal system and or the concept of constructive receipt. Now, in between the first notices, even in between the two notices, the first and the second notice being, first notice being the NTE and the second notice being the NDA, there is also an important process known as administrative hearing in between these two notices, written notices. Administrative hearing is also an important process, except that there are only three instances by which mandatory this compliance of administrative hearing is mandatory. Now, in all other cases of dismissal, administrative hearing is required, except when these three incidents with the court. First incident, if the code of conduct of the company itself requires that administrative hearing be conducted. If the code of conduct requires admin hearing, employer would have no choice except to really conduct the admin hearing. Second instance, if the employee required in writing, and I mean in writing, if the employee required in writing that an admin hearing be conducted, then the employer would have no choice except to conduct an admin hearing. And third, which is also an important thing, if the violation of the employee would require presentation of evidentiary matters such that the employer could not show proof of the violation until and unless evidences would be presented, then in all those three instances, the conduct of administrative hearing is required. Okay, going back, summing up again, the procedure as far as just causes is concerned. There is what we call NTE, okay, and there is the so-called admin hearing, and then there is so-called NDA. Now, in the admin hearing, the employer can also has a possible recourse insofar as imposition of what we call preventive suspension is concerned. In any event that the employee who has just violated, the possibility that the employee's presence will be inimical to the interests of the employer insofar as the pending issue of investigation is concerned, then the company can impose what the law calls as preventive suspension. It can be to a maximum of 30 days, where the decision to pay or not during the period of preventive suspension will be dependent on the culpability of the employee or innocence of the employee. Simply put, if the employee is found to be innocent, then all these 30 days will have to be paid. If the employee is found to be guilty of the violation, then 30 days may even be used as an actual days for suspension, and or it can penultimate to what we call dismissal. The 30 days is actually the maximum period. Employer can resort to a shorter number of days, but not to a period longer than 30 days. In any event that the investigation would require more than 30 days, the employer can extend the 30 days period, but immediately it is already a period with pay. It becomes an automatic paid leave immediately. Okay. Now, the procedure as far as the procedural due process as far as the other collective grounds, which I have referred to as authorized causes, is different. Is different. Again, going back, if it is a procedural due process for just causes, there is NTE, administrative hearing, and NDA. If it is, however, for what they call authorized causes, the procedure is about close to having a written notice as well, but it's a bit different. The first notice that you would have to send is what they call notice to the employee. Okay. In any event that the company would like to do retrenchment, redundancy, and or a medical separation, the first notice that has to be tendered by the employer to the employee would be what we call a notice of separation. The law requires that the service of this notice will have to be made at least 30 days before the actual date of separation. Okay, before the actual date of separation. The actual date of separation would have to be borne in mind by the employer. In any event that the employer would like to have a retrenchment 30 days from now, notices has to be sent to the employees affected. And I mean written notice. That's the first notice. Or what we call dismissal arising from authorized causes. The second notice required by law, this is actually required by the implementing rules and regulations of the Labor Code. The second notice is what we call notice to dole. It's a written notice to dole. Basically, the employer need not construct any letter, because the good thing is that this notice, this form, this written notice or written form is dole.gov.th downloadable. We call this form as establishment termination report form, or in the website of DOLE, you can click in the lower bottom portion of the website in the downloadable form, a form known as RKS form. Now, let me give an emphasis that this requirement of establishment termination report form is an IRR requirement, such that there are cases decided by the court invalidating the separation on account of authorized causes should there be failure to comply with what we call RKS, or establishment termination report form. And this is what distinguishes between the procedure as far as just cause and the procedure as far as authorized cause is concerned. In just causes, there is NTE, notice to explain, admin hearing, and then there is NDA. In dismissal arising from authorized causes, there is a notice 30 days to affected employee, and there is notice to DOLE, okay? And there is this final process known as payment of separation pay. The amount that the employer has to trigger to the employee by way of a separation pay will be discussed in the next succeeding slide. I just have to give an emphasis that there are various cases saying that the minimum number of notice to the employee should not go below 2 weeks period. Okay, while the procedure requires that there has got to be a minimum 30 days notice. However, there are cases actually decided by court saying that 2 weeks period will be the least period that the employer has to tender to the employee as far as authorized grounds for dismissal is concerned. Now, I have just discussed to you the procedure. Take note that earlier on, I have mentioned that to make a valid dismissal, there are two critical compliance that you have to do. One is the procedure, one would be the grounds. Now, the procedures, I have already discussed that, okay? Again, going back, just to summarize it to you guys, procedure-wise, it would be based on what grounds you are dismissing an employee. If it is just cause, NTE, admin hearing, and NDA. If it would be authorized causes, notice to employee, notice to DOLE, and separation pay. So that's as far as the procedure is concerned. Now, let's discuss the grounds. Grounds, guys, are basically exclusionary. What does it mean? For as long as the grounds is authorized by the labor code, then those are the grounds that you would have to invoke as far as employee dismissal are concerned. Okay. The grounds, again, there are as well two, the just cause and what we call authorized causes. Just cause, if you would like to refer to the textual provisions of the labor code, it is enumerated and listed in Article 282 of the labor code. Now, as far as authorized causes is concerned, it is enumerated and listed in Article 283. Article 283 talks about closure, retrenchment, and or redundancy. And Article 284, which talks about what we call as medical separation. Okay. Now, let's discuss first the favorite topic among HR practitioners. This topic pertaining to employee violation. Whenever a dismissal is triggered by an employee violation, this is what we call just causes for dismissal. And you have to have with you the provisions of Article 282 of the Labor Code. Okay, and don't be worried, guys. There is already a department order issued by DOLE sometime September 17 of 2016-15. This is Department Order 145-17, providing for the elements of each and every particular grounds that you can use to dismiss an employee as far as just causes is concerned. Okay, the first ground under Article 282 of the Labor Code is what we call serious misconduct. What is a serious misconduct? Serious misconduct, as the materials will tell you, is actually a transgression of whatever established norms of behavior which is required by the corporation in any work enterprise. Okay. The department order, as I was referring to earlier, provides for the following elements. One, there must be a misconduct, because we have to understand that every single violation of the code of conduct is an automatic misconduct. Okay, but not all misconduct is a ground for dismissal, simply because the law says that it has to be a serious misconduct to allow a dismissal. Now, this misconduct, as required by the second element, must be really that grave and of aggravated character. When do we say that it is grave and it's aggravated character? Well, previous Supreme Court jurisprudence will tell us that if a violation is evil per se, meaning it created a violation which is not really and not ordinarily acceptable in any civilized location, then that's evil per se. Classic example would be theft or taking of someone else's property. That's evil per se. Now, in various Supreme Court decision, the Supreme Court said that a misconduct, which is evil per se, can be used as a ground for serious misconduct. Okay. The third element, as you are seeing in the material, is what we refer to as performance related. Okay. If the failure of the employee, which is classified as serious misconduct, is somewhat or is included, necessarily related, or forming part of the obligation of the employee to the company, which is performance related, then that's the third element. The fourth element, as required by the rules, is that after having determined the violation, the seriousness, the employer makes a decision saying that the employee is really unfit for a continuous employment. With all those four elements, then you have a valid ground for dismissal, referred to as serious misconduct. On the materials that I'm showing to you, this is presented by the most recent department order on the topic. In this case of Autobus Workers Union, what was referred to as the violation is the uttering of obscene, insulting, and offensive words. This was classified to be a serious misconduct. Another ground is the so-called fabrication of time records. Okay. Well, during my time, we use a bandy clock to register our entries in and out. But right now, what is being used are so-called biometrics. I'm not so sure how fabrication can happen, but it is a possibility. In any event, that there is a fabrication involving the entry, the time in and time out of the employee, then it can be a ground for dismissal. On your screen, the third element that the third case cited by the department order is this case of Senco sales, where the Supreme Court said that using the employer's property for the personal gain constitutes serious misconduct and therefore ground for dismissal. Okay. Paragraph B of Article 282 is what we call willful disobedience or insubordination. Okay. Well, at least in the civilian world, insubordination is meted with the penalty of dismissal. But in the uniform and in the military service, I was made to understand that the Articles of War will provide for a much stricter penalty, and that I believe is musketry. At any rate, because we're in the private enterprise, insubordination will be meted with the penalty of dismissal from work. Okay, what does insubordination constitute? It is the act of an employee deliberately not complying the legitimate order of the employer, which order is work related. Take note of the term deliberate. There must be deliberateness as far as the non-compliance of the employee of the employer's order, lawful order is concerned, which is work related. So what are the grounds? Grounds as provided for in the department order would be: one, there must be disobedience, or what we call insubordination. Two, the insubordination is really wrongful and would have a perverse attitude, meaning very, very deliberate. Okay. And the order which was not complied with is work related and reasonable at that. And the employee would not want to comply with that order. The department order I'm referring to cited two particular cases. This case of Sentinel Security, where the security guard was or would not want to comply with the order of the agency to transfer a security post. The Supreme Court said that's a valid ground for dismissal, insubordination. In another case, there was a refusal to transfer a new work assignment. Supreme Court in this case of Philippine Plaza said that's insubordination. That's a valid ground for dismissal. I'd like, however, and I was reminded of a jurisprudence made by the court saying that the disobedience must be deliberate. Okay, there was a case decided by the court wherein the employee was caught outside of the workplace, caught by the police authorities for a violation. Then the employee was put behind bars, incarcerated. It took him quite a while to be able to put a bond so that he will be allowed provisional liberty. When he went back to work, only to discover that he's already dismissed on account of insubordination. Well, the Supreme Court said that abandonment of work and or insubordination in relation thereto, if it is actually a judicial restraint, meaning there is a lawful proceeding instituted against the employee, the court said that it's not a valid ground for dismissal. Okay. Another ground is what we call gross and habitual neglect of duty. Well, I need not emphasize to you guys that this basically and should be a work-related thing. There are basically two grounds here. Okay, one is the gross and habitual neglect, and the concept of habituality or repetition. Okay, the grounds cited, the elements cited is that one, there must be a habitual neglect of duty, and two, that the negligence is gross and there is habituality. Now, I'd like to relate this ground insofar as this practice known as performance evaluation is concerned. This is the proper ground to make use of in any event that the employee will be continuously failing in the so-called performance evaluation. Why? There will be habituality if it is a continuous failure in the performance evaluation. And this is a valid ground for dismissal. Okay. In fact, in this decided case of Labor et al. Versus NLRC, this is a 1995 case, the Supreme Court confirmed the fact that habitual tardiness and absenteeism, including abandonment, is a valid ground for dismissal. Okay. And another ground listed in Article 282 is what we call fraud. At times we refer to it as dishonesty, okay, or willful breach of trust. At times we call it as loss of trust and confidence. Okay, any act, as the case of Philippine Educational Company and Union of Philippine Education Company employee would tell us that any act or omission which is a concealment, and the employee is legally bound to present it to the employer. If there is a deliberate concealment, then it constitutes fraud and or willful breach of trust. Following are the elements. One, there must be an act or omission, or what we have referred to as concealment. And two, the employee is legally obliged to make a disclosure. And three, it was committed against the employer and or his representative. And four, it must be related to the performance of one's work. If all those four elements exist, then presto, you have another valid ground for dismissal. Following are some of the offered cases by the department order of DOLE. This case of tough form, where it was no less than the head of the supervisory group who's initiating the boycott against the corporation. The Supreme Court said that it's a valid ground for dismissal on account of loss of trust and confidence. I was reminded again of this concept, jurisprudence laid down by the court, saying that the evidence needed in any event that the employee will be dismissed on account of loss of trust and confidence will be dependent on the position classification of the employee. The rule goes like, if the employee is in a position lowest in the table organization, the degree of evidence needed to dismiss the employee on account of loss of trust and confidence is conversely proportional. Now, in any event that the employee to be dismissed occupies a ranking position in the corporation, the Supreme Court said that the evidence needed to dismiss him, again, is conversely proportionate, meaning there would be a lower degree of evidence needed to sustain a dismissal on account of loss of trust and confidence. Okay? I was reminded as well of a Supreme Court decision saying that there are two classification of employees who are susceptible for an immediate dismissal on account of loss of trust and confidence. These are classification made if only to provide us an exemplification as to what type of employees can easily be dismissed on account of loss of trust and confidence. These are two types of employee. The first type would be the so-called policy-making employees. These are the managers, the executives, because they're basically a policy-making entity in the corporation. So if you occupy a policy-making position in the corporation, presto, you can easily be dismissed on account of loss of trust and confidence. The second kind of employee are those employees who are said to be in possession or in custody of company properties, company funds, company asset. The jurisprudence laid by the court simply says and tells us that in any event that you are an employee holding on to the property of the corporation and you dissipate, made use of this asset for your own personal gain, then that's a valid ground for loss of trust and confidence. In some industry, there is this concept of those who hold on to the funds. There is this concept of overage, where there is an excess money, or underage or loss of funds that has to be accounted in favor of the corporation. It's basically a ground for dismissal on this particular um, um, element of Article 282. Okay, stealing surely is a ground, as you are now seeing on the materials. Okay, and there is even a mention here of a fictitious requisition slip, which is also a ground for dismissal, loss of trust and confidence. Again, whether you belong to the low-ranking level of the low-ranking position in the corporation, or you belong to the upper echelon of the table of organization, you are susceptible for a ground on this particular issue, a possible ground for dismissal. Except that, again, going back, as you go up the corporate structure, the degree of evidence needed to dismiss you will be conversely proportionate. It goes without saying that even the low-ranking employee can be dismissed on this particular account. Okay. What are the elements for this particular loss of trust and confidence? One, the act or omission or concealment. Okay, and that this concealment basically attaches to the confidence level given by the employer to the employee. Okay, and that the employee is holding on to the position of trust. I've mentioned that there are two kinds of employees holding on to the position of trust. One would be the policy making, two would be the property custodian. Okay, and that the confidence was basically lost because of a wrongful act made by these employees, two kinds of employees, and that there is actually there is failure to justify that particular act, and that there's really a genuine grounds, an element, a factual setup by which this particular ground may be invoked by the employer. Mind you guys that, as earlier shown, the court would not think twice to strike down any dismissal made by the employer if that grounds is actually based on bad faith. So going to the factual setup in this particular grounds, the Supreme Court would normally look into the succeeding and or prior antecedent acts that constitute the grounds of the employer is invoking here. Okay. The fourth ground, as provided for in Article 282, paragraph D, is what we call commission of a crime against the employer or company or employer representative or his family. Okay. What are the grounds? There are two grounds. One, there is an act or omission which is punishable by law. Two, it is committed by the employee which is subject for dismissal, either committed to the employer by the employee, to the employer, to the family, or to the representative of the employer. I'd like to bring to you guys that there are so many Supreme Court decisions already by way of jurisprudence saying that managers are basically representatives of the employer, such that if the employee, a low-ranking employee, will challenge, attack even a ranking officer of the company, this is the correct ground that the employer has to invoke. Again, ground for dismissal. Okay. We have here this case of Bulago oil tanker trucks as offered by the department order. The diversion of employer's product. This is basically involves a sales personality where there is a personal gain diverting the product of the corporation. The Supreme Court said that it is a commission of a crime. Okay. There is also a jurisprudence saying that it matters not whether the employee was acquitted in a criminal case triggered by the employer against the violating employee. Because again, the Supreme Court said that the burden of proof as far as administrative cases involving dismissal and the burden of proof as far as criminal cases, okay, involving the acts which constitute the dismissal. If the employer files a criminal case, eventually employee is acquitted on this account, it does not automatically make the dismissal as illegal. Why? The Supreme Court said that in administrative cases, the degree of evidence is needed as compared with criminal cases. So the word crime in this particular paragraph, fourth paragraph of Article 282, has to be read in the sense that, or in relation to the concept of an act done in the concept of a criminal definition, but not necessarily requiring conviction. Okay, and the fifth and the final ground, as far as Article 282 is concerned, which is the most pervasive and the most widely used ground by the employer, is the so-called Article 282 paragraph E ground, which is other analogous cases. Supreme Court made a declaration that sexual harassment, this constitute analogous case. When we say analogous case, remember I discussed to you some of the grounds earlier. If any of the elements do not exist complete by itself in any of those grounds, then that can fall on the so-called catch-all provisions of Article 282, and that is what we call as analogous cases. Okay, so what are the elements? Again, there is an act or omission specified in the earlier mentioned just causes grounds, and two, there is that particular willful act. There is a deliberateness, a voluntary act made by the employee in so far as that act is concerned that constitute the violation. Then that is actually an analogous ground. Okay, the Supreme Court said that for that particular act to be analogous, it has to be in relation to the four earlier grounds that as I have mentioned. If those elements are not complete, again, it can fall on the fifth ground, which is other analogous cases. Okay. Now, we're done discussing dismissal on account of employee violation. We're about to discuss dismissal referred to as authorized causes. How does it differ between a dismissal just causes and dismissal which is authorized causes? Now, in just causes, the employee made an act which is violative of Article 282, okay? Meaning there is an employee violation. In authorized grounds for dismissal, the employee has done nothing wrong, okay? Has done nothing wrong, except that there are circumstances allowed by law by which, despite the employee behaving properly, despite the employee performing properly and with a measure of performance required by the company, dismissal may still be effected by the employer. What are those instances? Okay. First is that which is provided in Article 283. We call this as installation of labor-saving devices. Now, this is more famous in enterprises which are manufacturing and or service related and or service oriented. With the technology nowadays, certain processes may be cut into half with the introduction of machineries, with the introduction of technologies. Now, if all the employee in this particular production line or service line will be affected by this introduced technology, then the affected employee may still be dismissed despite them doing no violation at all, may still be dismissed on account of Article 283, again, that is installation of labor-saving devices. Okay, this is the case of Pill Metal Sheet Union. Okay, What are the elements? One, there is an introduced machinery or contraption or devices, and the introduction was done in good faith by the company. The purpose of introducing this machinery is to hasten the operation, improve efficiency, lessen the operating costs, which obviously was done in good faith by the employer. And third element, there is no other available option to the employer except to institute the device or that so-called labor saving mechanism. And fourth, the employer will be using a fair and reasonable ground as to who gets to be separated in any event that this device technology is introduced in the process. So the employer is required to come up with criteria in the course of selecting who gets to be removed in the course. Okay. Article 283 also mentioned the term redundancy. You would immediately think of another term, which is the reverse of redundancy, which is retrenchment. All of these three grounds, labor-saving devices, retrenchment, redundancy, is covered by Article 283. Okay, these are all grounds for dismissal of the employee. We call that as authorized causes. Okay, again, there is nothing. The employee has not violated anything. Okay, except that one, employer may have introduced a technology or a device allowing separation because there was an improvement in the process. Two, there is a redundancy. What is this redundancy? This is a condition where the number of employees hired by the employer who are supposed to complete an activity is so numerous in relation to the number of activity to be completed. Okay, the employer is allowed by law to remove these excess employees by way of what we call redundancy. Okay, what are the elements? First, there is superfluity of the position of the employee, and there is an excess number of employee that makes the operation no longer economically viable. Okay, and third, the employer would like to introduce redundancy as a concept of good faith, not because it would like to subvert any employee rights such as unionism or provision for a particular benefit to the employee. So this redundancy is a recourse of the employer to improve the economic consequences of its operation. So there should be a good faith. And again, similar with the installation of labor-saving devices, there must be criteria that the employer has to use, who gets to stay and who gets to be separated. And final element, there must be an adequate proof to show that redundancy really exists. And what would that proof be? The number of employees based on your table of organization, list of employees, and the number of activities that your company has to do in relation to the quantity or volume of order or service activity that they have to complete. Ergo, if the number of employees is in excess of what is required, redundancy may happen. Okay? Retrenchment, as mentioned in Article 283, is also another ground. Okay? Retrenchment essentially is a concept by which employer would simply wanted to reduce the number of employees that it has in its employ. Okay? For whatever ground, but surely the reduction of employees is also to improve the economic condition of the employer. Okay? Whatever the employee would like to separate, wanting to improve its economic condition to avoid financial or fiscal reverses, then that is what we call retrenchment. Okay. The following are the elements. Retrenchment has to be undertaken simply because there are probable business losses that it wanted to prevent. Okay, and that these particular losses are not de minimis, not small losses, but substantial one and very imminent at that. Okay, and these losses are to be expected because it is imminent, and there is a good faith proof that the employer would show in so far as this particular loss is concerned. I'll be discussing also the so-called proof of good faith to show proof on this issue of losses. And again, similar with the last three, as far as authorized cause is concerned, there should be criteria as well as to who gets to stay, remain, and who gets to be dismissed by the employer on account of retrenchment. Okay. Um, Closure of business is also another ground. While there is no law requiring an investor to put up a business or an investment, there is also no law requiring an investor to continue with the business concern once it has been started. Therefore, this ground of closure is another element to separate an employee, even if the employee has done nothing wrong against the employer. It is a valid ground for dismissal. What are the elements? One, the decision of the board of directors of the corporation to shut down the operation. Okay, shutting down can be total. In any case, it becomes a closure, or partial. In any case, what will be invoked by the employer is the so-called retrenchment. Okay, and the closure was done in good faith, meaning it is really the remaining alternative for the employer to perform or to do because of reverses and or losses. And three, there is no other available remedy for the employer to recoup from whatever losses there is. Recoup would simply mean to recover from previous year's losses. Okay. Now, if there is a recoupment, then there can be a possibility that bad faith exists. But if there is no possibility that the employer would be able to recoup its losses from its previous year's operation, then that can be a viable ground for dismissal, which is what we call as closure of operation. Now, on the board, that what you're seeing right now is this concept of LIFO, last in, first out. If you would note, in redundancy, retrenchment, installation of labor-saving devices, there was a mention that the employer has to come up with criteria. Okay, criteria as to who gets to stay and who gets to be dismissed and or removed. Now, jurisprudence would have it that one criteria is what we call LIFO. Okay, LIFO as in last in, first out. What does it mean? Whoever was last employed and or recruited will be the very first guy who will be removed and or included in the separation. And that's a case, that's a jurisprudence also established in this Maya case, Maya Farm case, as I have already shown to you earlier on. Now, another authorized ground for dismissal is that which is provided for in Article 284. Okay, we call this as disease as grounds for termination, but to put it simply, we call this as medical separation. Although the term medical separation do not exist in the labor code, but for brevity, I think it would be much easy to call it as medical separation. Now, there is a magic number that you need to remember as far as medical separation is concerned, and that is 6 months. What does 6 months mean? If the employee is afflicted with an ailment or a disease, and the employee could not recover despite treatment, could not recover within a period of 6 months, then that can be a possible ground for a medical separation. Okay, what are the elements? Okay, one, the employee has a sickness or a disease. Two, this employee who's sick or disease, the afflicted disease is actually prohibited and or not allowed by law, and or it may be prejudicial to the employee himself who's sick, or prejudicial to the other co-workers who's associated with the employee. Okay, and or three, the third requirement, the third element is that to show proof, to show good faith in the course of medical separation, the element requires that there be a medical separation, medical certificate, sorry, issued by a public medical health practitioner. Take note, public medical health practitioner. So if it would be a mere certification issued by your company doctor, it may not suffice. What is required again by way of the third element is what we call a medical certification issued no less by a public health practitioner. Now, guys, if you would see and if you would recall, we have discussed just causes, one of the collective grounds for dismissal. Another collective ground is authorized causes. Now, what distinguishes between the two, other than the fact that in just causes, the employee made a violation, in authorized causes, the employee made no violation. Another distinction is that in any event that dismissal is effected arising from just causes, employee is not entitled to a separation pay. In contrast, if the separation is triggered arising from authorized causes, if the employee is dismissed from authorized causes, it simply means that the employee has done nothing wrong against the employer, except that the exigencies required by the labor code exist, therefore allowing the employer to dismiss him from employment. The rule says that there is this need to pay separation pay. This is what distinguishes an authorized causes with a just causes. This very element of separation pay. Now, on your screen is the computation required by law as to this concept of separation pay. Okay, if it is a separation pay due and owing to those employees who are dismissed arising from installation of labor-saving devices and or redundancy, the rule says that the payment has to be 1 month or 1 month pay per year of service. Okay, on your screen there is a sentence with an asterisk that will lead us to the conclusion that if and when an employee has an excess service number of weeks or days in excess of 6 months, the law says that that excess of 6 months will be rounded up to the closest 1 year. For example, if the employee has been with the company for 2 years and 6 months and 2 days, that would simply mean that the computation has to be made rounding up to the nearest 1 year. That makes it 3 years. So the employee who's subjected to redundancy and or installation of labor-saving devices will be receiving 3 months pay as compared to retrenchment. Okay. In retrenchment, the law says that the payment has to be, but the separation pay has to be made by way of a computation as 1 month or half month pay per year of service. Now, how does it differ with redundancy and installation of labor-saving devices? In redundancy, installation of labor-saving devices, that's 1 month per year of service. In retrenchment, that is half month pay per year of service. Again, the same formula goes. If the employee has service in excess of 6 months, then it has to be computed rounding up to the next nearest number of year. Okay. Another computation that you have on the board is the so-called closure of business, which is computed just like a retrenchment. I'd like to give an emphasis, though, that if the dismissal arose from what we call closure to avoid business losses, if you would note on your screen, there is no entitlement for a separation pay. Okay? Again, there is no entitlement for a separation pay. If it is an ordinary closure, separation pay is due and owing. If it is closure because of business losses, serious business losses, no separation pay is due to the employee. I'd like to give you a specific case decided by the court. I think this was a decision handed down sometime 2014. This case of Capital Medical Center. This is a famous hospital. At one point in time, they closed what they call a section of their hospital, industrial service unit. They had to let the doctor in charge. A case transpired. The Supreme Court said that there is actually no business losses because what has been presented to the employee, to the doctor who's in charge, is not really in compliance with what the requirement of the law is. And so the Supreme Court said that the dismissal on that particular count is void. Okay, so there's no valid dismissal on account of business losses in that particular case. And finally, this computation of separation pay, as far as medical separation is concerned, the rule will tell us that it will have to be paid the separation pay just like the so-called retrenchment and or closure of employment. Okay, and I think that would be all for the moment. Until and unless you have any question.
We have first question from Hazel Hazel. What is the treatment to separation of employees due to closure of business due to acquisition?
Okay, acquisition is a process whereby one company is assumed by the other. Okay, there are some technical issues that you need to decipher as far as uh, merger and or acquisition is concerned. If the acquired company will be shut down and the personality will be subsumed by this particular surviving company, okay, then the employee who lost his employment should be entitled to separation pay. Okay, but the practice that goes right now is that the surviving company who gets to assume the services of these particular employees in this particular situation will be entitled to separation pay. Okay, but
There's a follow-up question from the same participant. Before we pay him the separation pay.
Before paying the separation pay, again, the procedural requirement, issue a notice, 30 days notice to the affected employee. Okay. Concept of quit claim and the waiver. Okay. In exchange for the last pay of the employee. I'd like to caution you guys that there is already jurisprudence saying that this quit claim, which normally includes a clause where the employee resigning and or dismiss can no longer sue the employer upon receipt of the final pay. There's already jurisprudence saying that this quit claim, if at all it has a legal validity, will only be a validity insofar as proof of receipt of the final pay. This cannot be used to bar prosecution by the employee, the dismissed employee, against the validity of the dismissal made by the employer.
Okay. So what happens if the employer did not explain within 5 days the reason for termination?
Okay. The 5 days period is actually a period of time by which the employee would have to explain. It's not actually a period of time by which the employer will have to explain the violation. So the 5 days period of time is for the employee to explain the violation. Now, if the employee would not explain within that period of time, then there is what we call a concept of waiver. What happens next? The employer can sum up all gathered evidences and decide on the case already, with or without the explanation of the employee.
So can you give us tips on how to legally and ethically terminate employees? How can we avoid legal problems?
Well, ethically, that's probably another topic, but legally, complying with this concept of grounds, which is substantial due process, meaning you have to have a ground to dismiss, and two, you must have observed the correct procedure. If you have ground to dismiss, observe the correct procedure, as I have discussed earlier on, then surely it becomes a legitimate dismissal. Okay. However, I'd like to caution you though. There are cases decided by the court as far as serious misconduct is concerned, where what is involved by way of a violation is what we call theft. Okay, theft as in taking of the property of the corporation. There are cases where the Supreme Court said that regardless of the value of what has been taken by the employee, theft is a theft and therefore grounds for dismissal. But there was also a case where the employee has been with the company for quite a while, has served the company for quite a while, and there is merely one violation, and that violation is actually the theft committed. The Supreme Court said that when the employer dismissed the employee on account of that theft, but taking into consideration the long years of service of the employee who was dismissed, the Supreme Court said that that dismissal is too harsh a penalty. Therefore, there is that concept also of too harsh a penalty rule. Now, if the employee to be dismissed has recorded violation, okay, and the last violation was used to dismiss him, then that can justify the dismissal. But if the employee has long recorded good performance or no violation at all, and then here comes a violation, boom, one time. If the employer would like to dismiss him on that particular ground, then the application of 2 hours a penalty rule may apply.
Okay. So if an employee is always on sick leave, but we're able to always provide a medical certificate, different sicknesses, minor and major, can we still consider giving grounds?
No, it's actually not a ground for medical separation. You know, in HR, there are some remedies that you may want to avail. There are some activities that you may want to do. One of them is what we call home visit. I would strongly suggest that you try to use this approach of home visit. In any event that there is an actual home visit and you get to discover that the employee is feigning sickness, then that's a serious misconduct. But if at all the employee is really sick, okay, at an interval schedule, sick, every now and then sick, but there's really sickness that transpires and there is proof of that sickness, well, my strong suggestion is send him out to a medical evaluation already because probably he's suffering from something. But the point is, with that interval of sickness, which is not really a ground for medical separation, no dismissal can ever happen.
Okay, we're very sorry for the technical problems a while ago. So, sir, can you repeat the question in kanina regarding the medical separation?
Okay, again, going back, the question posted is that can an employee be dismissed if this employee is suffering on and off from various ailments? Okay, can the ground provided for in Article 284 be used as a ground for dismissal, which is medical separation? As I was saying earlier, in HR practice, you may want to make use of this concept known as home visit. Okay, this has been a proven strategy already. If home visit is conducted and it was discovered that the employee is feigning sickness, then it's a serious misconduct. But in any event that a medical home visit was conducted and true enough the employee is suffering from an illness at various interval, it cannot be used as a ground for a medical separation. However, my strong suggestion is probably to refer this particular employee to a possible workup with your company physician and or accredited clinic to be able to discover what medical condition there is, because it can probably ripen into some future ground as well.
Her question, before we pay him separation pay.
Before you pay the separation pay, as soon as all the grounds exist, one, you have issued the notice, 30 days, you notified DOLE, you have no choice except to pay the separation pay. That is on the presumption that you have invoked the correct ground, which is medical separation. Again, what are the elements required for medical separation? There must be a sickness, cannot recover or recuperate for a period of 6 months, and that is medically certified by a public health practitioner.
Okay. So if there is no company code of conduct, will it satisfy the procedural due process for any violation of an employee?
Well, if there is no code of conduct, my strong suggestion, get hold of Article 282 of the Labor Code. Article 282 is actually the entire summarization that you can ever come up with as far as code of conduct is concerned. No matter how thick or thin your code of conduct is, surely it will fall in any of the grounds of Article 282. Okay. Again, going back, if you have no code of conduct, you have the grounds, Article 282. If you wanted to make sure that you are doing the correct procedure, again, we have already discussed the so-called twin notice, the NTE or the notice to explain, and the notice of disciplinary action, that is after having shown proof that there is indeed a violation. Again, in between these two, there is this conduct of what we call administrative hearing. I have already discussed to you that administrative hearing is required only in 3 instances. One, if you have a code of conduct, or surely you have none, obviously you will not be required to conduct admin hearing. Two, if the employee required the conduct of admin hearing in writing, again, the request to conduct admin hearing must be in writing. And three, if the dismissal or if the violation of the employee requires submission of evidentiary matters. So in all those 3 grounds, you need to conduct administrative hearing. Otherwise, dismissal becomes void.
Okay. So in case the employee has been in an activity or project for years already because it is a tracking study and requested to rest for a while from that project because the project is hard to do despite of the superior instructing to be assigned in that project, can it be grounds for insubordination?
Well, the question reads as in the employee was allowed to rest, eventually to resume work, but he has been an employee on a project base?
Project for years already.
Project for years already. The question is, can it be a ground for insubordination? Again, going back to the elements of insubordination, there must be deliberateness on the act of the employee not to observe the lawful or legal work-related order of the employer. So it goes without saying that if the employee would not want to comply with the lawful order, and that is a requirement of the job, then that can be an insubordination. But in your question, if the rest is needed and it's not deliberately intended to subvert the requirement of the company, then it may not be used as a ground for insubordination.
Okay. If the employee has an existing loan from the company, can we deduct the remaining loan from the separation pay?
Okay, here's the good thing about separation pay vis-a-vis outstanding loan balance. Okay, in accounting, there is this concept of compensation. Okay, this is the accounting term, compensation. But in loose English, we normally call it as offsetting. Okay, compensation or offsetting is a condition where one person becomes creditor and debtor to the other. Meaning, the employer is obligated to pay the separation pay or the final pay to the employee. The employer stands as a creditor to the employee, but the employee is also indebted to the employer. So in that relation, the employee is also a creditor to the employer. If that happens, one and the same person becomes a creditor to the other, then offsetting or compensation can happen. And mind you, it requires no authorization. Not a check off is required from the employee to authorize the employer to deduct it from the final pay. Automatic offsetting can happen.
Sir, I think you need to clarify this one. Even if the employee already filed a partial disability in SSS, we need to send him to the public doctor before we terminate the employee and give him the separation.
Well, as I was saying earlier, if a disability application is filed with the SSS, the SSS medical practitioner can be classified as a public medical practitioner. My strong suggestion, get hold of the records with the SSS and make use of it as the third element. Remember, there are three elements. The sickness cannot recuperate within a period of 6 months and publicly certified by a public health professional, meaning you only have two requirements needed, and presto, you can trigger a medical separation already.
Again, sir, what is the treatment to separation of employees due to closure of business due to acquisition?
Again, going back, acquisition. Acquisition, one company acquiring the other. There is a surviving company and there is a company that gets to be dissolved in the course. The employee, once this company has been dissolved, is automatically entitled to separation, okay, as I have already shown to you. Now, the separation pay should have been tendered to the employee at the time of their at the time of the corporation's closure. Okay, but in practice, I get to realize that there are some mergers even that happens that what the company, the surviving company, would do is to simply issue a certification honoring the length of service of the employee from the previously closed corporation. Okay, that's also acceptable, except that I'm reminding the affected employee that they should have been entitled to the separation pay already. In any event that their stay in the new company becomes topsy-turvy and then they get to be separated by this new corporation, they have to be reminded that they are already entitled to the separation pay way back, and therefore they can demand for it.
Okay. Is the 30-day resignation rule mandatory? Are there instances that it can be overruled?
Oh, well, this is a good thing. If you would check on the labor code, 7 books of the labor code, uh, all of it are basically a listings of what we call as employee right. Okay, book 1 to book 6. Okay, book 7 being the transitory provision. It is a listings of employee right. But if you get to discover this 30 days requirement is an obligation given by the labor code to the employee. It's not a management prerogative at all. This is a labor code provision saying that employee has to tender a 30 days notice prior to resignation. Now, what would be the consequences? If the employee will not comply, then possibility of damage uh, would happen to the corporation. Therefore, the corporation may be able to recover. But if the corporation agreed to a lesser number of notification period, then that's perfectly fine. Because the 30 days notice is a requirement to the company, not a requirement to the, it's a requirement to the employee, not a requirement to the company. Meaning the company can waive the 30 days notice, but the employee cannot tender a shorter period of notice prior to a resignation.
Okay. Can the employer hold back the back pay or 13th month pay because the employee did not follow the 30-day resignation? Note that when the employee was promoted, he or she did not sign a new contract.
Well, the question is that can there be a withholding of the final pay, okay, in any event there is a dismissal? The rule says that the separation pay and or the final pay of the employee has to be given to the employee close to the same period of separation. But understand that there is also a process known by the employer, process known as clearancing procedure. Clearancing procedure is a reasonable requirement of the employer reason to be able to establish the fact that the employee has no obligation in favor of the employer, such that if the employee has some accountabilities to the employer can even withhold the equivalent amount, if not the entire amount, if the employee is obligated to the employer. Okay, so meaning there's a possibility of an offsetting that can work.
If an employee under cross-training program refused to transfer to a different department without justifiable reason, will that be ground for insubordination? Or an employee has the right to refuse to
Okay, which is a good question. Employee was sent to a training. Surely, when the employee was sent to the training, the employer would expect that after the training, this employee will be in agreement to transfer to some other location in the corporation. Now, but the question is, can the employee refuse the transfer? Answer is that, remember the change in work position is actually a management discretion, it's a management prerogative. If the transfer to be effected is lateral in character, lateral as in the same position classification, an employee has no right to refuse transfer. Okay? If, however, the transfer would have an impact of promotion, jurisprudence will tell us that promotion should be consensual, meaning employee and the employer has to agree on the terms of the new engagement. So therefore, if the employee would refuse the transfer simply because that transfer is a promotion and the employee would refuse, there can be no insubordination. Summing up, if the transfer is lateral, okay, within the same level, employee would refuse, then that's a ground for insubordination, ground for dismissal.
Is it legal to hold 1 month salary if an employee has an existing loan pay? His last pay won't cover the total amount of his remaining loan balance.
Well, if the loan is presumably valid and the final pay of the employee will not approximate, will not even cover the balance of the loan, then it's legitimate for the corporation to apply the concept of compensation or offsetting. Meaning, okay, employer will no longer release the amount of the final pay to the employee, but it is presumed that this amount will be applied and used to pay off the loan obligation of the employee.
If issuance of final pay exceed the 30 days as indicated in the company policy, is there a provision in the law regarding this, given that employee has completed his clearance?
Okay. In fact, the jurisprudence will tell us that the obligation to pay the final pay to the employee will be within a reasonable period close to their actual separation. Okay? As in close to their actual separation. Now, the 30 days, it's actually an industry practice. Well, I can only presume that this 30 days period is actually a reasonable period to allow the employer to check on the employee's accountability. However, if the clearancing procedure is already completed and the employer will still hold on to the final pay, that becomes illegal. Employee can trigger a case, a monetary claim case with the NLRC. If the amount is 5,000 and below, the case has to be lodged with the regional director's office of DOLE, having jurisdiction to the corporation's location. But if the amount is in excess of 5,000 pesos, then the case would already have to be filed with the NLRC.
Okay. So, sir, what does involuntary termination of employment mean?
Well, involuntary termination, in the first place, there's no such thing as involuntary termination. Okay? But as it appears in the labor code, termination becomes involuntary simply because it was triggered by the employer. But there is this concept also known as illegal constructive dismissal. Okay? This is a condition in labor practice whereby employee would not really want to resign, okay? But he was literally forced and coerced by the employer into resigning because of some circumstances that the employer has been introducing to the employee, such that the employee would rather resign rather than suffer from the inconvenience that the employer is providing.
Okay, so I think that's all. There's another one, sir. This is the last. Is it illegal to hold the last pay if a resigned employee failed to complete the clearance process?
Well, the company has to determine with reasonableness whatever liability that the employee would have. Because anyway, it is within their procedure, it is within their structure. If the corporation would be able to establish whatever liability the employee would have, then the employer can always retain whatever amount is due to the employer and release back whatever amount is due to the employee. Just the employee's protection.
Okay, so that's it for today, sir. That's all of the questions na po. So,
Thank you very much.
thank you, Attorney Ray. And
Thank you,
thank
Kay.
you to all our viewers. For more updates on our upcoming events and learning sessions, you may like our page on Facebook and visit our website at www.emap.org.ph. Thank you and good afternoon.
Thank you.